Under Section 205 of the Land Property Act 1925, the definition of land is wider than one's common understanding. Land, as read from the article, includes land of any tenure, mines and minerals, whether or not held apart from the surface, buildings or parts of the building, whether the division is horizontal, vertical, or made in any other way, and other corporeal hereditaments, also a manor and advowson, rents and other incorporeal hereditaments, and an easement, right, privilege, or benefit in, over, or derived from the land. The purpose of land law is to determine what interests there are in the land and what a person can do with the land. These interests are dependent on whether the said land is registered or not registered. Until 1897, unregistered title was the only system regulating land in the UK. To prove that the vendor has the title to his land, all he has to do is produce a document known as a title deed. However, it was considered a traditional system that has many flaws. One obvious problem is that title deeds could be potentially lost or damaged. It was also impractical for some landowners as the root of the title could not be traced. Since 1893, registration of land gained popularity in the House of Lords when the view that it was in the interest of the landowners were known. Compulsory registration of land took place in central London. By 1990, all lands in the UK were required to be registered. However, there was an inefficient system of land registration. The only method available then was by way of conveyancing, which was considered to be slow and costly. Thus, Land Registration Act 1925 was passed to overcome these cumbersome problems. Lord Wilberforce in Williams and Gaines Bank against Boland said that compulsory registration is designed to simplify and cheapen conveyancing. It is intended to replace the complicated and voluminous title deeds of property by a single entry on the register to the strength of which land can be dealt with. With land registry, the purchaser is also able to locate all relevant information relating to a property on the register of title. This includes both who owns the property and rights owned by third parties. LRA 25 also introduced three distinct principles, namely the mirror principle, the curtail, and insurance principle. Essentially, the mirror principle laid down by Theodore Roth in 1963 said that this fundamental principle of land is supposed to provide certain information, and the information should be reflected precisely. The mirror principle suggests that the register should be a mirror for all proprietary rights that includes estate and interests that exist in any given piece of land. Nonetheless, the LRA 1925 failed to eradicate all cracks in the mirror. Instead, it preserves the relevance of certain interests which may override registration. Land law faced their first fundamental reforms through the LRA 25, where many principles and practices have developed over centuries. Moreover, a comprehensive system of land registration in England and Wales has also been developed through this act. However, due to the changes of economy and social aspect of land ownership, flaws have surfaced from the Land Registration Act 1925, which leads to a need of a statute to fill in the lacuna. Therefore, LRA 2002 was enacted and it was aimed to create a truly transparent, accurate, and comprehensive register. The basic tenet was that title to land should be recorded in a register and guaranteed by the state, so there is a certainty within conveyancing transactions for the buyer, seller, and those individuals who may possess one or numerous third-party rights. As a comparison, the LRA 1925 saw several difficulties for the purchaser, which included taking time and money to read the title deeds, risking the forging and inaccuracy of the deeds, as well as the unnoticed and binding effect of an equitable interest or the binding effect of a legal one. LRA 02 was introduced to impose compulsory registration on most dispositions of interest in land and therefore guarantees a good title. The principle underlying the Act is the mirror principle. In addition, the LRA 02 has also aimed to introduce e-conveyancing, which allows registration and inspection to be done easily with electronics.
The main purpose of the land registration system is to ensure that the land may be sold freely, and the rights entered of the register must be discoverable by the inspection of the register and allow the potential buyer to be protected by knowing the effect on the land in advance, providing certainty towards the purchaser and third parties who had right over the land. This also upholds the mirror principle, where it shows the full character of the registered land. Firstly, here is a reform made by the LRA 02 which upholds the mirror principle, which is the compulsory first registration for this. However, only 85% of the potential registrable titles are in fact registered. Prior to LRA 02, the compulsory registration only applies to the list of greater than 21 years to be registered. The driver of the change was based on the survey of British Property Federation annual lease review that the average lease length has fallen progressively, and the average was just over 10 years in 2001. If this was not changed, most of the property transactions in England and Wales will most unlikely be recorded in the register and defeat the purpose of having a complete and accurate reflection of the title of the land at any given time. Amended by LRA02, a lease which is for a duration of 7 years or more will now be subjected to compulsory registration with its own individual title. Therefore, more title of land will be registered, allowing the purchaser to inspect the existing title in land from the register. Moreover, there is still limitation on the compulsory first registration of the lease, as the lease will only be compulsory to register when the term is more than 7 years, leaving short-term leases such as parole leases and leases more than 3 years but less than 7 years are registered. So the title existing in the short-term leases will not be shown in the register. Therefore, it has shown that the mirror principle does not really reflect the full character of the land, and the maxim of caveat emptor, which means buyer beware, still exists. Despite of the fact that the land is registered, the purchaser still has to inspect the property either physically or by inquiries. When a piece of land is registered, Section 50M of LRA02 held that the registered proprietor shall be deemed to have been vested with the legal estate. A person registered with a title to an estate or charges has both legal and equitable titles. Therefore, the titles of the landowner will be recorded in the register, allowing the potential buyers to inspect on the record of the title. If the purchaser were to purchase that piece of land, they will be required to register their title in the time limit of 2 months, or the legal title will remain in the transferor, which will be holding the land on trust for the new owner until the registration is completed. Therefore, when the purchaser registered their title, it confers them the title over the piece of land, recording them into the root of title. Moreover, LRA02 aimed to further reduce the reliance of overriding interest by providing protection to the third party's right in registered land through notice, which is stated in Section 34 of the Act. Notice can exist in the form of agreed notice or unilateral notice, where the distinction is the presence of the consent of the registered proprietor of the land. Once the interests are registered, it will bind the subsequent purchaser of the land. Besides that, the third party right can also be protected by means of restriction, which controls registered proprietors' ability to deal with the land. Restriction indirectly protects the right of the third parties by preventing a transfer of land unless the terms of restricted are complied. Last but not least, as stated in Section 25-27 of Schedule 2 to the LRA02, there is the mechanism of registrable charge, which is the requirement of registering the mortgage to transform it into legal mortgage. Once it has been registered, the mortgage will be bound to the subsequent transferees of the mortgage land. Unless the mortgage is paid off by the proceeding of the sale, if it is not registered, such as mortgages take effect as equitable interest only and will not have priority over purchaser of the registered title unless protected by the registration system in some other way. Therefore, the mortgagor will be able to protect their rights of mortgage. The proceeding of overreaching is whereby certain equitable rights in land which might otherwise have enjoyed protection in the system of registration on the occasion of a sale of that land to a purchaser for value are swept off the land and transferred to the purchase money that has been paid. In addition to this, the process of overreaching is when certain equitable rights which should otherwise have enjoyed protection in registration on the occasion of a sale of that land to a purchaser for value are swept off the land and transferred to the purchase money that has just been paid. When this occurred, the equitable rights are said to be overreached and no longer bind the purchaser, even though they might have fitted exactly into the category of overriding interest. An example of successful overreaching can be seen in the case of City of London Building Society and Flag, as the two trustees of the City of London Building Society has paid the capital monies to Flag, rendering his interest to the property being overreached. However, in contrast, the case of William Green Banks Limited and Bolden is an example of an unsuccessful claim of overreaching. Therefore, the concept of overreaching helps reflect the register better as it protects purchaser of the property as it wipes out certain interests of trustee and beneficiaries of a land. the system becomes cleaner and safer for those who would like to purchase the land, as those interests no longer binds the purchaser, as those interests are attached in the money that is given by a third party for the property.
Adverse possession can be established by exclusive physical possession of land with the intention to possess the land to the exclusion of others, including the owner on paper. This reasoning was decided in decision of the Court of Appeal in Buckinghamshire and CC and Moran, and the judgment in PJ Pie Limited and Graham. The RIA 02 drastically changed the regulation of the effects of adverse possession on land whose the title is registered. The principle of limitation was how adverse possessor acquire a better right to land than the paper owner. However, the RIA 02 completely changed this provision. Section 96 RIA 02 states that there is no period of limitation against the registered title and no sense in which a registered proprietor can lose title merely because another person had adversely possessed the land for a period of time. No period of possession itself can deprive the registered proprietor of his title even if factual possession and intention to possess is established. Section 6 of RIA 02 establishes a procedure where adverse possession may apply to the registrar to be registered as proprietor of the title. This means that the registered proprietor can rely on the registrar to notify him to any adverse claim to which he can respond to safeguard his interests. Assuming no consent is given, the adverse possessor cannot become a new registered proprietor unless either of three exceptions are established. First will be the estoppel, where the adverse possession ought to be registered. The second, where the adverse possessor is for some other reason entitled to be registered as proprietor. And the last one, where there is a boundary dispute. This clearly shows that the effort by the RIA 02 to uphold the mirror principle. As mentioned, mirror principle still remains as a fundamental principle to the system of registered conveyancing, and it has been strengthened by the new Act in several ways. The significant change by RIA 02 was the removal of certain overriding interests, which is an enforceable interest that does not require registration. It is unfavorable to the purchaser if they are unable to discover those rights by inspecting the land register. Therefore, it leads to a current position where these rights to be overriding, they must be entered into register. Thus, the purchaser protection from overriding interest without registration has been improved through the reform by RIA 02. As overriding interests of third parties can be inspected through the register, nevertheless, there is still a list of remaining interests stated in Schedule 1, which listed interests which overriding first registration, and Schedule 3, which listed interests which overrides registered disposition. These interests are referred to as the crack in the mirror, because the nature of these interests are not reflected in the registrar, and yet they have the ability to bind. The principle of overriding interest itself is considered a departure from the mirror principle. The crux of the problem is that there is not everything that can be expected to be registered because they are either too impermanent or too important to be subject to a registration requirement. The subject of a legal easement under overriding interest has been proven to be problematic. Easement are the rights to use of another's land as defined by Law Commission. This category of overriding interest replaces the complexity of Section 70 sub 1A of RIA 25, and the Schedule 1 Para 3 highlights that equitable easement will not override a first registration. This is because prior to the first registration, an equitable easement should have been registered as a land charge under the Land Charge Act 1972. Schedule 3 finds that there are fewer easements will override a registered disposition than it will at first registration. According to Para 3 Schedule 3, it is important to note that any easement that qualifies as an overriding interest continues to override irrespective of the provision provided. Legal easements that are granted or reserved after the 13th October of 2003 out of a registered title are excluded from the category of overriding interest because it amounts to a registrable disposition as seen in Section 72 sub 2D of the RIA 02, and in order for them to become legal interest, they are required to be registered. This means that legal easement can override those that are expressly granted out of an estate that itself is not registered, including leases of 7 years or less, and those that are granted impliedly. Moreover, legal easement will also override if they are either registered under the Common Registration Act 1965, the person who is disposing has actual knowledge of legal interest, fulfills the objective test of the inspection of land on a reasonable, careful manner in which legal interest is discoverable, or the person entitled to the benefit proves that it has been exercised in a period of 1 year ending with the date of the disposition. Unregistered legal easement will bind disponees if disposee knows about the existence. If its existence objectively is objectively obvious, and neither of these, but the easement has been exercised within a year. For easement, Schedule 3 tries to reach a compromising position between to ensuring their protection in the disposition and the need for the purchaser to be aware of such interests before he completes his purchase. It can be said that the RA02 seems to lean towards the side of a purchaser rather than the one benefiting from the interest of the land.
We will now look into the matter of actual occupation. It is arguably the most important part of overriding interest. Schedule 1, paragraph 2 and Schedule 3, paragraph 2 discusses actual occupation. There is no statutory definition of the term actual occupation. Case laws concerning actual occupation under Section 70, subsection 1, subsection G, LRA 25 can be used to define actual occupation. The general understanding of actual occupation is when a person claiming an overriding interest over a land being able to prove that he has a propriety interest in the said land and he is in actual occupation at the relevant time. The legal reach of overriding interest is limited to the factual reach of the occupation, or, to use the words of Schedule 1, paragraph 1, the interest overrides only so far as relating to the land of which he is in actual occupation. This reversed the Court of Appeal's decision in Ferrishurst Limited and Wallside, where Ferrishurst was in occupation of part of the land as an under-leasing, but held an option to purchase the entire land compromised in the superior leasehold estate. And because of the actual occupation, he had the right to purchase the entire land, which was held to override. In Schedule 1, his overriding interest will be limited to part of the land that it occupies. Thus, this begs the question of what constitutes actual occupation. Actual occupation is determined by circumstances of the cases. Most of the times, it's an analysis of the facts of the case, meaning actual occupation in LRA 02 was discussed in Thompson and Foy with further discussions in the Court of Appeal in Link, Lending and Bastard. Lord Wilberforce in Williams and Bullen interpreted Section 70, subsection 1, subsection G of LRA 25 is that the word actual just means physical presence and not entitlement in law. Actual occupation doesn't necessarily involve personal presence of the person claiming to occupy. In Link, Lending and Bastard, the claimant was found to be in actual occupation despite being in a psychiatric unit elsewhere. Lord Wilberforce said the actual occupation arises when someone had a physical presence on the land. In other words, he gave the phrase a literal meaning. Actual occupation can also be proved through occupation by an agent. Lord Oliver in Abbey National Building Society stated that actual occupation involves a degree of permanence and continuity and that a fleeting presence is insufficient. Stan Securities and Caswell confirmed that mere presence of some claimant's furniture does not count as actual occupation. However, Justice Lewinton has a reference to mere presence, and usually because furniture can amount to actual occupation because it shows a degree of continuity and permanence of occupation. In Melbourne and Cheshire homes, actual occupation was established through the erection of a fence to keep intruders out despite the land being unused. Schedule 3 provides additional conditions that further restrict the circumstances that an interest holder can claim to be in actual occupation so as to override a registered disposition. Basically, there cannot be a claim of overriding interest if both limbs of the qualifications are established. The first limb, if occupation would not have been obvious on a reasonable, careful inspection of the land at the time of disposition. This is because the occupation must be discoverable, not the right. The second limb, even if occupation is undiscoverable, third parties' interest will still take effect through actual occupation as overriding interest if the transferee had actual knowledge of the right. Moving on to the last main part of overriding interest. Paragraph 1 and paragraph 1A of Schedule 1 talks about certain leases and relevant social housing leases. These are legal leases that is 7 years or less, which will override first registration. All leases that were stated in LRA 25 before LRA 02 took place will continue to override and no additional actions need to be taken to protect them. However, the 3 exceptions to overriding status of short leases are of a special kind and are required to be registered as titles in their own right irrespective of the length of the lease. The three exceptions are grants of leases out of unregistered land in pursuance of Part 5 of the Housing Act 1985. The first exception is that the right to buy provisions. 2. The grant of a dwelling house to a private sector landlord where the tenant's right to buy is preserved. And third, the grant of a lease out of unregistered land that takes effect in possession more than 3 months from the date of grant. A lease, if 7 years or less, is likely to be in possession and discoverable, hence it qualifies as an overriding interest. Paragraph 1, Schedule 3 states leaseholds for 7 years and less will override a registered disposition and will be automatically binding. More than 7 years is registerable as individual titles. Equitable leases of any duration are excluded and are protected by notice on the register, or it takes effect as an overriding interest through discoverable actual occupation of the tenant.
The aim of the LRA 2002 is for total registration, or in other words, to ensure as much as possible the ownership of land in England and Wales takes the form by title by registration. There is an undeniable improvement in the LRA 2002 in comparison to the LRA 1925 in terms of the reflection of the mirror, as a number of interests will be brought onto the register through the operation of e-conveyancing. If the operations of e-conveyancing were to be extensive, there will be further development, as some property rights will not exist at all unless they are electronically registered, which is stated under Section 93 of the LRA 2002. In this sense, the registration of title in accordance to the LRA 02 can protect most of the third parties, as the interests registered will be binding upon the purchasers of the land. This would make the register more reflective of the interest registered of a particular land. More than that, the register is argued to be more reflective because of the changes in regards to adverse possession. Prior to LRA 02, the person who has completed 12 years of adverse possession before the 13th of October 2003 is entitled to be registered as a proprietor of the land. This trust no longer exists. The mirror principle is seen to be upheld as of now because there exists a clause that encourages the registration of these adverse possessors. The problems of someone else having the right over land over the owner on paper will be curbed, as the registrar will reflect the owner and the nature of the rights of the burdened land. However, it is unfortunate that the register will never be a perfect mirror, as everything cannot be expected to be reflected on the register. The mirror principle refers to the idea that the due registration of a land title must reflect all the important and significant details that a purchaser must know before buying the land. This is mainly due to the existence of overriding interests. The problem now is that social and judicial developments have enlarged the opportunity for the existence of overriding interests, with the fact that purchasers might not be able to determine whether the interests exist by inspection of land. The most notable example is Petit and Petit, where the right of equitable ownership stemmed from, which is part of the reason why the Law Commission reduced the scope of effect and implementations in Schedule 3 LRA 02. Overriding interests ought to be retained, yet it cracks the mirror. These interests have successfully confused and disorganized its obligation to convey its message, rendering the mirror principle redundant. Although these overriding interests do arise in a disorganized manner, there is a reluctance in abolishing it due to its considerations of the underdog in situations. It is argued that the LRA 02 tackled much on what was inaccurate, incomprehensible, and inconvenient in the LRA 25. The 2002 Act ensured that overriding interests are valid only when they are or should be obvious to the purchaser conducting a reasonable inspection of land. It tries to draw a balance by limiting the scope of overriding interests. Moreover, an occupier's right will prevail only if the purchaser has knowledge of occupation or if following a reasonably careful inspection of the land. The occupation was evident. LRA 02 encourages the registration of unregistered titles. Simon Gardner mentioned that the argument for these overriding interests are far more practical than to abolish them. To abolish them would mean in violation of Article 1 of the ECHR of the right of property, as the layperson is not aware of the rights in this respect. Additionally, Bogus argues that these overriding interests should exist as they protect the vulnerable individuals. Dixon echoes the arguments and adds that it will be impractical and unrealistic to expect every title to be registered. It is undeniably that the mirror principle is too far-fetched, as it seems to be too great of a burden to a purchaser to inquire about the property at such great lengths before the purchase. The crack in the mirror deepens as the true intention of the register is disregarded. With that being said, how can the mirror principle truly be a perfect reflection of all proprietary rights? England and Wales must look into the role of e-conveyancing, which is promoted in the LRA 02. E-conveyancing is dependent on the register being as up-to-date as possible, as well as the duty of disclosure as provided in Section 71 of the LRA for a general duty of disclosure. This way, the registrar can be more mirror-like. The LRA 02 is a step forward to a more holistic guidance for registered land. However, the mirror principle as it stands today is merely theoretical. There is hope that the future of e-conveyancing as well as the development of the law, the mirror principle itself will ingrain itself as one of the hallmarks of English land law.